Welcome to the James E. Rogers College of Law. I'm Professor Jason Craig, and I'm pleased to welcome all of you for the 10th annual Darrow K. Soll Memorial Criminal Law and Justice Lecture. I'd also like to welcome those of you who regularly attend our Wednesday weekly speaker series, sponsored by the Program in Criminal Law and Policy. Each week, the college hosts a discussion from experts in the field, from judges, prosecutors, defense attorneys, formerly incarcerated individuals who join us to speak about important issues with our community. If you're interested in learning more about this speaker series, please contact me after the event. The Soll Memorial Lecture has become an institution at the college, and I think we're set to hear another provocative and moving talk today. Darrow K. Soll was a 1991 graduate of the University of Arizona College of Law, and among the important accomplishments in his life, Darrow was an outstanding attorney who worked tirelessly to promote justice in the criminal justice system. Given Darrow's work, it's fitting that we are going to hear today from Angela Davis, Professor of Law at American University Washington College of Law. And Professor Davis asked me just to clarify, there might be one or two of you in the room thinking that there's a different Angela Davis here to speak to us this afternoon. It's not Angela Yvonne Davis, but nonetheless it is Angela Davis from Washington, D.C., who carries her own powerful voice. Professor Davis has had a distinguished career as a lawyer, a teacher, and a writer. In each area, she's challenged us to examine critically how the state exercises its immense and unmatched power in the criminal justice system. Professor Davis's work has focused specifically on the role of the prosecutor in the modern criminal justice system. In doing so, she's explored several profound questions, including what role should prosecutors play in ending mass incarceration? Has the institution of the prosecutor evolved to a point where it has consolidated too much power in the system? And how should the system and all of us respond when prosecutors abuse their power or become unresponsive to the community? Throughout her career as a teacher and lawyer, Professor Davis has also focused on the vast racial disparities that continue to plague our justice system. This focus is most recently explored in her 2017 book, Policing the Black Man. Professor Davis's powerful voice commands our attention. She built it as a public defender and later as the executive director of perhaps the best criminal defense organization in the country, the Public Defender Service in the District of Columbia. Her voice continues to be important as she trains countless students and budding attorneys who aspire to protect the Constitution as public defenders. But you don't have to take my word for it for how powerful Professor Davis's voice is and what distances it has reached. Rather, you can look to comedian Samantha Bee. When Miss Bee wanted to explore the power prosecutors have on her late-night comedy show, she lifted a video of Professor Davis giving a talk on C-SPAN. So the academic talk from C-SPAN Book TV reached TBS late-night comedy. That's the power of Professor Davis's voice. Today in her lecture, Prosecutors, Democracy, and Race, Professor Davis will share her voice and her experiences with us. Please join me in welcoming Professor Angela Davis for this year's session.
Really generous introduction. I appreciate it. And I want to thank Dean Miller. I want to thank Bernadette Wilkinson for making this visit so wonderful for me, and really everyone here who's responsible for inviting me to deliver the 10th annual Darrow K. Soll Memorial Criminal Law and Justice Lecture. I had an opportunity to read a bit about Darrow Soll's life, and among his many extraordinary accomplishments, I learned that he was a public defender. And as a former public defender myself, I can say that I'm truly honored to be delivering this lecture in his memory. The topic of my lecture today is prosecutors, democracy, and race. Our criminal justice system is broken. We have the highest incarceration rate in the world. The quality of justice that a person receives depends far too often on his income, whether he can afford to pay an attorney or post bail. Public defenders carry huge caseloads. They often don't have the resources they need, investigators and other resources to provide the zealous representation to their clients. Since 1989, 2,198 innocent people have been exonerated after having been wrongfully convicted in our criminal justice system. And the system is fraught with unwarranted racial disparities at every step of the process, from arrest through sentencing. The system is truly broken. But I believe that it can be fixed. And I believe that prosecutors, more than any other official in the criminal justice system, have the ability, the power, and indeed the responsibility to right many of the wrongs in our system. And today I'm going to talk about their power, ability, and responsibility to right one of those wrongs, and that is the unwarranted racial disparities in our criminal justice system. And I'm also going to talk about our power as citizens to hold them accountable through the democratic process. First, the power and discretion of prosecutors. The power and discretion of American prosecutors cannot be overstated. They are indeed the most powerful individuals in our criminal justice system, bar none. They control the system through their charging and plea bargaining decisions. The charging and plea bargaining decisions are the most important decisions in our criminal justice system. The prosecutors alone control those powers. They make those decisions. They make them behind closed doors and with very little accountability. We pay a lot of attention in our society to police officers. And that's right. We should pay attention to them, especially in light of what we've learned in recent years, all these unwarranted killings of young, unarmed black men. Police officers have an incredible amount of power and discretion as well on the streets to stop, frisk, search, and indeed use deadly force against individuals. So we should pay attention to police officers and hold them accountable. But police officers can only bring an individual to the courthouse door. It is the prosecutor who decides whether an individual remains in the courthouse, what happens to that person, whether they're going to be charged, and what they'll be charged with. Prosecutors may charge an individual with whatever the police officer recommends, or they can charge that individual with a lesser charge or with a greater charge, or they can decide not to charge them at all. And it's totally within their discretion. And a charging decision has tremendous consequences for an individual accused of a crime because there's such a proliferation of laws in our system in both the federal and state systems. They have a wide range of options when they're making this decision. And I'll give you an example to illustrate my point. Let's say a police officer arrests a person who's in possession of 10 bags of cocaine. Well, the police officer can come to the prosecutor and recommend that they be charged with a number of offenses, but the prosecutor has a number of options. That prosecutor can charge that person with possession with intent to distribute cocaine, which is a very serious felony, and in most jurisdictions it carries a mandatory minimum sentence, sometimes of as much as 10 years in prison. Or the prosecutor can decide to charge the person with simple possession of cocaine. Even though they have the right to, the ability to charge them with a greater offense, they can charge them with simple possession. That's a misdemeanor, which could carry maybe a year or less, maybe even probation. And the ramifications of this decision are far-reaching and permanent. If that prosecutor decides to bring that felony charge, the defendant not only faces that 10-year mandatory minimum sentence in prison, but will also, if convicted, be saddled with a felony conviction and all of the associated collateral consequences. They might lose their right to vote. They might not be able to apply for public housing, public benefits. Very difficult for them to find a job. And if they're an undocumented person, they might be deported. Despite the importance of the charging decision and these life-changing consequences, prosecutors are not required to explain or justify this decision to anyone. They're not required to follow any rules or guidelines when making the decision. The decision is not made in open court, and there's no public record of why or how that decision was made. It's made behind closed doors without any transparency whatsoever. And it's very easy for prosecutors to charge an individual with a crime. They only need to meet the very low standard of probable cause. It's like the lowest standard in our criminal justice system. Roughly, it means more probable than not. That's way lower than the much higher proof beyond a reasonable doubt that they must meet in order to convict an individual of a crime. And that gives them a tremendous advantage at the other decision-making point that I mentioned, and that's the plea bargaining step of the process. Prosecutors also control plea bargaining. And if you're not familiar with that process, it's where a person's charged with a number of crimes and the prosecutor might offer for them to plead guilty to one in exchange for the prosecutor dismissing all the other offenses. The person has to give up their right to trial, but they gain something because they don't face the possibility of being convicted of all of the crimes. I'll give you an example. Let's say a person is arrested who's suspected of being a drug dealer. And let's say the prosecutor is able to charge that person with 5 counts of distribution of cocaine. And each one of those counts is a 10-year mandatory minimum. Well, that person is facing 50 years in prison. And when I say mandatory minimum, that means the judge must sentence them to 10 years if they're convicted. So that person's looking at 50 years in prison. And the way plea bargaining would work is that the prosecutor would go to the defense attorney for that person and say, hey, I'll tell you what, I'll make your client a deal. I'll allow him to plead to just one of these 10-year mandatory minimums, and I'll dismiss the other 4. Well, you could see how under those circumstances, even an innocent person might feel pressured to accept that deal. Why? Because going to trial is risky business. You never know what a jury's going to do, and if that jury comes back and he's convicted of all of the offenses, he's going to go to prison for 50 years. And the judge has no discretion for a drug offense, because many of these drug offenses do carry that long prison term. And even if the person's innocent, oftentimes, in fact, most times, they're going to be represented by public defenders. Unfortunately, in most jurisdictions, public defenders, as I mentioned earlier, are overworked. They have huge caseloads. They don't have the resources to investigate a case. They're under incredible pressures. And let's say in my example, the public defender says to the prosecutor, well, I need to discuss this with my client. And many times prosecutors will put deadlines on these deals. They'll say, all right, this deal's good until 5 o'clock tomorrow, and your guy has to take it tomorrow. After that, the deal's off the table. And the defender might say, well, wait a minute. I have an ethical duty to investigate the case for my client to try to decide if my client has a defense. And the prosecutor can, and they often do, say, deal's up tomorrow at 5. And so it puts public defenders in the untenable position of having to go to their clients and say, look, you might have a defense, I don't know, but I don't have time to investigate, or in many instances, I don't have the resources to investigate. And if you want this deal, you have to take it by tomorrow, right? And that's not really being the zealous advocate that lawyers should be, but public defenders often have to do this. This happens in courtrooms across the country every day. This is what passes as justice in the United States of America. And it happens a lot because 95% of all criminal cases are resolved by way of a guilty plea. 95%. If you watch some of the many law and orders, and I think there's a whole bunch of them, SUVD, I don't even know all the names of them. There are a lot of them. But if you watch them, you think all these trials were going on in the United States. Not so. There are a lot of guilty pleas going on. And unfortunately, under the circumstances that I just described. So that's a problem. That's an unfair system. But there's also another problem that I mentioned, and that's the unwarranted racial disparities in our criminal justice system. Black men are 2.5 times more likely to be arrested than whites. Black men are 21 times more likely to be killed by police officers than white men. Data from the United States Sentencing Commission revealed that between 2007 and 2011, black men received sentences 19.5% longer than white men sentenced for the same crimes. African Americans are incarcerated in state prisons at a rate that's 5 times the imprisonment of whites. And in 5 states, the disparity is more than 10 to 1. In 12 states, over half of the prison population is black. Now, there are many complex reasons for these disparities, including the socioeconomic reasons, causes of crime. But the research shows that discretionary decision-making by criminal justice officials at every step of the process play a significant role in causing these disparities. By a number of officials, police officers, judges, but prosecutors as well. Prosecutors play a role in creating these disparities. Their charging and plea bargaining decisions often produce and perpetuate these disparities. And again, to illustrate my point, let me use a couple of hypotheticals. I'm a law professor, so we like hypotheticals. So let me use a couple of hypotheticals to illustrate my point. Suppose a prosecutor is trying to decide whether to charge two different individuals with drug offenses in his office. One of the defendants is a white high school senior. His name's Brian. Brian was arrested for selling cocaine to his fellow classmates. The arresting officer recommends to the prosecutor that Brian be charged with distribution of cocaine. And in this particular jurisdiction, it carries a 5-year mandatory minimum sentence in prison. Now, this is the very first time Brian's ever been arrested. His parents hire a private attorney who's very skilled, and that attorney informs the prosecutor that Brian is addicted to cocaine and that he was selling cocaine only because of his habit. That attorney also informs the prosecutor that Brian's parents have found a residential drug treatment program that he is scheduled to participate in so that he can deal with his drug addiction. He also tells the prosecutor that Brian has been admitted to a prestigious university, that he has a bright future, and that a felony conviction and a prison term would ruin his life. The prosecutor considers all those things and agrees to dismiss the case if Brian successfully completes the drug program. That sounds like a fair result, right? So let's look at another case in this prosecutor's office. Another defendant, an African-American young man named Marcus, who's a high school dropout. He's also arrested for selling cocaine on the streets, however, in his community. Police officer recommends the same charge, distribution of cocaine with the same mandatory minimum 5-year sentence. Marcus is represented by a public defender with a heavy caseload. Like Brian, Marcus has no prior convictions. He has been arrested several times for misdemeanor offenses, but no convictions. His lawyer informs the prosecutor that Marcus also has a drug problem and that he was selling to support his habit as well. But Marcus's mother cannot afford to put him in any kind of drug program, and there aren't any free programs available in his community. And he's a high school dropout after all, so he's not going to college. So the prosecutor charges Marcus with the 5-year felony drug offense. And because he has an arrest record, the prosecutor doesn't offer him one of those sweet deals where he can, maybe plead guilty to a misdemeanor. So he goes to trial, he's convicted, and he's sentenced to mandatory 5 years in prison. So, Brian and Marcus committed the same offense, both were first offenders, both had a drug problem, but the prosecutor dismissed Brian's case, and that decision created an unwarranted racial disparity. Now, there's a lot of reasons why the prosecutor might have made this decision, right? She created a racial disparity, but is she racist? I don't think so. She may have had an unconscious bias towards Brian, perhaps seeing a bit of herself in him, bright future, etc., and not wanting to ruin his future. May not have had that same empathy for Marcus. Maybe she considered the fact that Marcus had prior arrests. That's something prosecutors should consider. But maybe those prior arrests were the result of racial profiling, right? After all, he wasn't convicted of any of those crimes. The prosecutor might have wanted to offer Marcus the same deal, but there were no drug programs, so what's the prosecutor supposed to do? So this disparity might have been the result of unconscious racial bias, or it might have been the result of the consideration of race-neutral factors that just happened to create an unwarranted racial disparity. Or it might have been a little bit of both. In either case, the disparity is unjustifiable. So you can see it's complicated, these reasons. Similar disparities occur with crime victims. Suppose a prosecutor is considering how to proceed in 2 cases in her office, 2 burglary cases. Let's talk about those victims. Another example. One victim is an African-American woman named Cynthia. Her apartment is burglarized. The burglar takes a television set, some costume jewelry. The police make an arrest. The prosecutor mails a notice to Cynthia's apartment and asks her to come down to the prosecutor's office for a witness conference. Cynthia gets the note. Well, first of all, Cynthia maybe doesn't get the notice. Maybe she lives in public housing where her mail gets stolen, she doesn't get it, and she doesn't show up at all. Or maybe she gets the notice and doesn't show up because it's a weekday and she does day work and she doesn't have vacation time. And if she doesn't show up for work, she'll either get fired or not get paid. So she just doesn't show up. Or let's say the prosecutor, and so if she doesn't show up, the prosecutor's going to think, oh, she doesn't really care anything about this case, so I'm just going to offer a plea or dismiss the case because she didn't show up. Maybe she did care, but that's a conclusion that a prosecutor might make based on Cynthia's not showing up. Or maybe the prosecutor calls her and repeatedly calls her and convinces her to come down. And then when Cynthia comes down, the prosecutor looks at Cynthia and talks to her, finds out that Cynthia's a high school dropout. She's not very articulate. She's not well dressed. Maybe she has a drug possession conviction that, if she testifies, is going to be revealed to the jury. And the prosecutor decides, well, I don't think I want to take this case to trial because I don't think that she'll make a good witness and I'm probably not going to get a conviction. So she offers a sweet deal to that defendant who ends up with probation. Fair? Maybe. Second case involves a white woman named Amanda who's also a victim of a burglary. Someone breaks in, they arrest someone, notice is sent out to Amanda. Amanda shows up early, and on time or early. She's a lawyer, she's a partner, so she can go to work whenever she wants to. And so she comes down, she's educated, she's articulate, she's poised, she's well dressed, she makes a good witness, and she's demanding that this person be prosecuted. She's interested. She's a victim who's interested. So the prosecutor takes the case to trial and that particular defendant is convicted. Again, these decisions create a racial disparity. Similarly situated victims' cases were treated differently. Were they the result of racial bias, racism? Maybe not, probably not, certainly not intentional racism. Maybe it wasn't racial bias at all. The American Bar Association has what's called standards for the prosecution function. They also have standards for the defense function. And these are guidelines that the American Bar Association writes and publishes that prosecutors should follow, sort of best practices for them. And so those standards list a number of factors that prosecutors should consider in determining whether to charge or offer a plea bargain, so on. And one of the factors that the American Bar Association suggests that prosecutors take into account are the victim's views, whether they're interested in prosecution or not, right? I mean, prosecutors don't represent, they're not the lawyers for victims, they represent the entire state, right, which includes the defendant, of course. But the victim's word should mean something. And the American Bar Association standards suggest that prosecutors take the victim's wishes into account, and that certainly makes sense. So the prosecutor may very well have seen Cynthia's failure to show up, or if she did show up, the amount of time it took her to show up, as a lack of interest in prosecution on the part of Cynthia. So maybe she took that into account, fairly so. Another factor that prosecutors are urged to take into account is the strength of the case, right? You shouldn't go to trial in a case if you don't have a strong case because it's a waste of resources, it's going to put all the witnesses, victims, etc. through all this and the defendants. So if you don't have a strong case, you shouldn't go forward. Well, maybe the prosecutor considered the fact that Cynthia had a drug conviction or that she wouldn't make a good witness. All of these are things lawyers take into account. Am I going to get a conviction if I have a witness who's not able to convince the jury, or who the jury is just simply not going to believe for fair reasons or not? So maybe she decided that that was a factor to take into account. Consideration of both of those factors would have encouraged her to take Amanda's case to trial. Amanda was reliable, articulate, she wanted to go forward, thereby increasing the likelihood of a conviction, making her a stronger case. So you can see, again, this is complicated stuff. Although the white victim appeared to have received favorable treatment, the decisions of the prosecutors don't necessarily reflect racial bias. Again, Maybe she did have some bias, what's called implicit bias, which I'll talk a bit about in a minute, towards Amanda and against Cynthia, maybe not. Or maybe it was, again, those neutral, race-neutral factors that ended up creating a racial disparity, an unwarranted one. If prosecutors charge African Americans with crimes while declining to charge similarly situated whites, she might be engaged in something called race-based selective prosecution. And that's a violation of the Constitution, but it's really difficult to prove in a series of cases. The Supreme Court has made it very difficult to prove selective prosecution. You practically have to prove intentional racial discrimination, and I don't think that that's what's going on. I don't think that prosecutors intentionally discriminate against people based on race. If it happens, I think it's extremely rare. And if race does play a role, I do think it's probably what's called implicit bias, if any of you have heard of that. It's the unconscious views that, quite frankly, all of us have, that are as a result of stereotypes that we're exposed to throughout our lives from the media or wherever, that causes us to feel a certain way about people based on their race or ethnicity or skin color or body size or hair color or whatever. And we're not even aware that we're having these feelings about these people, right? It's the thing that causes a woman who's on an elevator with a black man to just move away and hold her purse a little bit closer, not even aware she's doing it because she sees a black man and she sees fear and crime. It's unconscious. It's not even intentional. And everybody suffers from it. There's a test you can take online called an IAT. It's by Harvard. Every time I take it, I stop because I'm afraid to take it. Because everybody, I know I have the bias, everybody has them. But when people in power, like police and prosecutors, are making life-changing decisions based on those implicit biases, it's a problem. Prosecutors have played a significant role in causing and enhancing the racial disparities in the criminal justice system. However, I believe that they have the power and the discretion to take steps to eliminate or at least reduce it. And I believe that the election of prosecutors who prioritize racial fairness and pledge to take steps to achieve it is essential to eliminating racial disparities in the criminal justice system. So now I'd like to talk about the last part of my talk, and that is prosecutors and democracy. Prosecutors and the electoral system. We all know that the American democracy functions through three branches of government, right? The legislature, the judiciary, and the executive. Each branch serves a different function, and we have this great system of checks and balances to ensure that no one branch exercises unlimited power. The prosecution function falls squarely within the executive branch. So in theory, the legislative and judiciary branches should serve as a check on the power of prosecutors. In practice, however, neither branch has effectively done so. Although the Supreme Court has certainly required prosecutors to perform their functions in accordance with the Constitution, the court has also protected the power and discretion of prosecutors, as I mentioned through the cases I mentioned earlier. And with regard to the legislative branch, neither the United States Congress nor state legislatures have restricted prosecutorial power. On the contrary, they have expanded that power through the passage of mandatory minimum sentencing laws that have served to amplify the significance of the discretion of prosecutors in the criminal process. Accountability is a core tenet of democracy. We demand accountability from those to whom we grant power. And as the most powerful officials in our criminal justice system, prosecutors should certainly be accountable to the people that they serve. Now, most prosecutors are held accountable, in theory, through the electoral process, right? Now, you should know that only about 10% of all criminal cases are prosecuted in federal court. 90% of all criminal cases are handled on the state and local level. And on the state and local level, the vast majority of prosecutors are elected officials. In all but 5 jurisdictions, Delaware, New Jersey, Rhode Island, Connecticut, and the District of Columbia, prosecutors are elected officials, and there are thousands of them across the country. They run for office every 2, every 4 years. In theory, that process holds prosecutors accountable, right? And if you're not satisfied with the job your district attorney is doing, and again, they're called state's attorneys and district attorneys, depending on the jurisdiction. If you're not satisfied with the job they're doing, you have the power to vote them out of office. In practice, the electoral system does not very effectively hold prosecutors accountable. Why is that? Because their most important duties, the charging duties and the charging and the plea bargaining processes, those decisions happen behind closed doors, not in public space. So we don't know what the plea bargaining and charging policies are of our prosecutor. Most people don't know what those decisions are. They don't even realize what they are. And when prosecutors run for office, they don't say, here's what my plea bargaining policies are, and here's what my charging policies are. They don't talk about those things. Most of them talk about, how tough they're going to be on crime. And if they have an opponent, and most times they don't, the opponent says, I'm tougher than that person, right? That's all you hear. Now, in recent years, we've been hearing something different. There's some focus now on diversion and other things. I'll talk about that momentarily. But they certainly don't talk about plea bargaining and charging policies. And most of them run unopposed and serve for decades. People simply do not pay attention to district attorney races. They just don't. And so there's no accountability. And most prosecutors don't feel the need to be held accountable. One of the inherent challenges is most of them run unopposed. The democratic process cannot hold prosecutors accountable unless we, the public, becomes more involved in prosecutorial races, exercise our civic duty. We have to become more informed about the duties and responsibilities of prosecutors so that we're equipped with the information to ask questions and demand responses. Because prosecutors have so much power, if we elect prosecutors who are committed to fairness and who are committed to racial justice, those prosecutors can make a difference. And I want to tell you about one of those prosecutors. John Chisholm is the district attorney for Milwaukee County, Wisconsin. And I want to talk a little bit about John. He demonstrated his commitment through his participation on a program called the Prosecution and Racial Justice Program. This is a program that I was on the advisory board for. It was started by the Bureau Institute of Justice in New York. And the program involved the collection and analysis of data in prosecution offices to determine the impact of their discretionary decisions. And the way the program worked was that the staff at Vera developed a series of performance indicators that focused on 4 important stages in the prosecutorial process that involved the exercise of discretion. The initial screening of the case, the charging decision that I talked about earlier, the plea bargaining decision, and the final disposition of the case. And then they would do an analysis. They would go into these prosecutors' offices and do an analysis to determine whether similarly situated defendants were being treated differently based on race. Those examples I gave you before, right, where the prosecutor may not know, but this analysis it revealed whether that's what was going on. And the goal of the program was to help prosecutors exercise discretion in a way that reduced the risk of racial disparity in the decision-making process. So it was a pilot program, and a number of prosecutors volunteered to get involved in it. John Chisholm was one of those prosecutors. He said, wow, I care about racial justice. I want to know, is this going on in my office? And so they did do the study in his office. He opened his office to them, and they immediately began to do the analysis, and the result came back showing that there were stark racial disparities in the prosecution of 4 offenses in Chisholm's office: possession of drug paraphernalia, prostitution, resisting or obstructing an officer, and domestic violence cases. So John immediately took action to eliminate these disparities. He implemented an early intervention program that resulted in either the dismissal or reduction of charges for people who completed the program. Now, many of you may have heard about diversion programs that prosecutors' offices have. If you're a first-time offender and it's a really low-level offense, you go through a program, your case gets dismissed. Many prosecution offices do that. But this was a different kind of program because John did not limit it to misdemeanors. He included a wide range of felonies. If persons were charged with a wide range of felonies, they were eligible to participate in this program. They didn't focus on the offense, they focused on the individual person. Now, obviously, people charged with serious violent offenses were not eligible, but there are a lot of felonies that are not serious violent offenses, and he included those. And he basically, what he said was because only 10 to 15% of the cases in Milwaukee were the serious violent ones, he really felt he could make an impact. And so he started this program, and eligibility was determined by a detailed assessment of the individual defendant. They do a questionnaire of each defendant to look at a number of factors, their criminal history, their background, their lifestyle, other factors. Instead of focusing on the charge, they focus on the individual. And once an individual was admitted to the program, they were closely supervised. They participated in programs that addressed their needs, like drug programs, employment programs, educational programs. And he's making progress in Milwaukee. He prosecutes many fewer low-level drug offenses. He doesn't prosecute drug paraphernalia cases at all. He drastically reduced the number of misdemeanor prosecutions, and the number of African Americans sent to prison for drug offenses was cut in half since 2006. Now, John Chisholm is just one example. There are other examples that demonstrate that the electoral process, despite its flaws, can hold prosecutors accountable. A number of incumbent prosecutors were defeated by challengers in 2016. In 2016, in about 17 races across the country that I'm aware of, incumbents were challenged by a new breed of prosecutor. Prosecutors who actually ran for office on what I call a progressive platform. A platform that promised fairness, justice, second chances, and a reduction in incarceration. And in 14 of these 17 races, the progressive prosecutor won. So there's reason to believe that the electoral process may become a more effective means of holding prosecutors accountable. More prosecutors have begun to support criminal justice reform. John Chisholm, by the way, was re-elected after implementing that program. Prosecutors like Kim Fox in Chicago, Aramis Ayala in Orlando, and Larry Krasner in Philadelphia campaigned on themes of racial justice and reducing incarceration, and they won their elections. Their successes have inspired others who are committed to racial fairness in the criminal justice system to run for office, and many of them are running this year. And if this trend continues, perhaps the democratic process can work to effect change. If those of us who care about fairness and racial justice work to elect progressive prosecutors and hold them accountable, with time and hard work, we can fix this broken criminal justice system. Thank you.
Thank you, Professor Davis. We have until quarter after, so we have time for Q&A. So I'll try and keep a queue up here. I would just ask you to announce your question loud enough so those of us on the other side of the room can hear. And Professor Davis will try and repeat the question in the microphone so we can hear as well. So questions from the audience. Yeah.
Do prosecutors like Mr. Chisholm, did he make what he was doing in his community available then through the Prosecutors Association? I forget the name of it.
Excellent question. So I think you all heard it, but the question was, did he make what he did available to other people? And the answer to that is yes. Actually, if you go to the Vera Institute, you Google Vera Institute of Justice, their website, and type in Prosecution and Racial Justice Program, even though it's a pilot program that's over, they have actually a handbook that they created for prosecutors who want to do this. They also have the results. They explain what happened in John Chisholm's jurisdiction. All of that's available on the website. And I'm involved in a number of projects, still working with John, and I always encourage them, when you go to the National District Attorneys Association's meetings, you should be preaching this gospel, because they don't want to hear it from people like me, but they certainly can hear it from others. And so, yeah, excellent question.
Chris.
Do you think judges have a useful role here to shed light, for example, during the plea colloquy, asking questions about how the plea was arrived at, including the use of deadlines or things like that within their discretion?
Absolutely. I think judges should play a role. Judges in most jurisdictions can't get involved in the plea bargaining process. They can't make prosecutors offer a deal or not offer a deal, but they can certainly try to shame them, and I've seen judges do that. Why are you bringing this garbage in front of me? Go back and, settle. But they can't ultimately force them to do it. And some prosecutors feel that pressure, some don't. But I do think judges play a role in holding prosecutors accountable. There are ways that they can do it, and it's not the topic of this conversation, but for example, there are Brady violations. There's a constitutional requirement for prosecutors to turn over exculpatory evidence, and oftentimes they don't. It's a huge problem, and a lot of judges don't hold. They have the power to hold them accountable for that, and they don't. with plea bargaining and charging, they have less power, but they can speak out, and I do think it can make a difference.
And front row.
In the 17 races that you mentioned, how many of them were partisan, and nationally, at all the different levels of jurisdictions, how many of those, just vague percentages, are partisan races?
When you say partisan, you mean like there's a Democrat running in most of them? It's complicated though, because I've actually been doing some work on this with a group that's working on this particular project. And you know, most of the time, the Democrat is the person who's the progressive, but not always, right? There's a prosecutor in San Joaquin, I think is how it's called, California, named Tori Salazar. I've been working with her on a project, and here's the implicit bias once again. I just assumed she was a Democrat because she's so progressive and she's doing such great things. And I was meeting with her last weekend, and she's amazing, and she's doing all this project. She even apologized to the whole community for the racism and the criminal justice and all that. Anyone's ever done that. And we're chatting, she's like, you know, I'm Republican, right? I'm like, oh. Okay. But oftentimes it is, and there's primary, it works different in every jurisdiction. Sometimes, you know, the primary will end up deciding the race because it's a particular, either Republican. Sometimes there's a primary and then it goes all the way to the general. So it varies from jurisdiction to jurisdiction. But I will say, you know, again, most of the time it's Democrat, but there are Republican. And there's some jurisdictions like in Dallas, right now, John Crusoe, who used to be a judge and is now, he just ran for district attorney. At one point he was Democrat, and he switched over to Republican, then he switched back to Democrat. And some of these jurisdictions, like they'll just switch parties just because they want to do good work and they know which party's going to win. I mean, it's crazy. It's how politics works, you know, sometimes.
I have a question about police brutality. In the past several, well, of course years, but it's more known nationally because of Facebook and things like that. The police officers are never held accountable. What are your thoughts on fixing that process?
Wow, I could have done this whole lecture on that. I actually started to, but I'll try to give a 2-minute answer. Very, very good question. So, yes, these killings of unarmed black men, which is for the book Policing the Black Man that Jason held up, is primarily about. As you know, these killings have been going on since the time of slavery, but really, quite frankly, because of social media and cell phone cameras, they're coming to light now. And many, many tragic cases where we've seen with our own eyes police officers killing these men unjustifiably. There are a lot of reasons for it, including the law and a lot of other things. But prosecutors play a role because, as I mentioned before, it's really easy for prosecutors to bring charges. The standard is probable cause. Right? They charge people all the time. It's so easy to get an indictment. There's a saying that a grand jury will indict a ham sandwich. I don't know what that means, but whatever it means, what they're saying is it's really easy to do. If they want to bring an indictment, they can. In most of these cases, they have not charged the police officers at all. And in the very few cases, and after people have protested what they charged, the juries have come back with not guilty or hung jury, and even in cases with. And so I think it's terrible because I think what's going on here is that you've got prosecutors, there's a bias issue, right? There's a conflict of interest, I think, inherently, because prosecutors work closely with police officers. The police officers are their witnesses. And so, you know, there really should be either a special prosecutor, in my personal opinion, who comes in from another jurisdiction who does not know that police department to bring those cases because there's a conflict going on there. And there's been a call for that in many instances. So, yeah, it's a huge problem because there's a double standard there for sure. And, you know, people see that kind of unfairness. Really, if we want people to obey the law, we've got to make sure it's applied fairly. People become very jaded because when they see police officers getting away with things like that, you know, you wonder why people don't obey the law. They don't have any respect for it because they feel like it's not being implemented fairly.
Lord.
Do prosecutors ever get in trouble for being too lenient? Are there ramifications
For being too
for
lenient?
letting people off too often, or?
Right. When you say get in trouble, the prosecutors really don't get in trouble for much of it. And I'm not just being facetious. Like the way that they get in trouble, I guess, is either they can be voted out, right? Or there are ethical rules, right? Because there's something called bar counsel but rarely are prosecutors brought before bar council. There's actually only one rule, Rule 3.8 of the professional rules of model rules of professional responsibility that applies to prosecutors, and rarely are ethical charges brought against prosecutors for misconduct. But for being lenient, I guess one could say if you're in a jurisdiction that thinks that the prosecutor is being too lenient, I guess the electorate could vote them out because they're thinking that they're not being tough enough. I suppose that could happen.
Okay, there in the front row.
Do you see a trend in punishing or reprimanding prosecutors for prosecutorial misconduct? Because I just read an article yesterday in San Francisco where a prosecutor was charged formally by the State Bar of California. I forget what he or she did, but it involved a trial, and someone was convicted who should not have been.
Right, so the question was whether prosecutors are punished for misconduct. Very rarely. I've written about this in my first book, Arbitrary Justice. There's a whole chapter on it. You can count on one hand the number of prosecutors that are referred to bar council, even when there's been a finding in the court of prosecutorial misconduct. They are rarely referred to bar council. I have my own theories about why that happens.
And what are they?
So, very quickly, first of all, I think defense attorneys are probably in the best position to know about the misconduct when it happens, obviously, because they're there. But defense attorneys, particularly if you're a public defender, you're in a difficult spot, right? Because you're going to refer this prosecutor to bar counsel, and then you've got to work with that prosecutor's office, and you got to get a fair deal for your next client, and so they're feeling a little afraid to sort of like, and I don't mean this literally, you know the old saying, if you shoot at the king, you got to better kill him. I don't know, I'm paraphrasing. I'm not suggesting prosecutors be shot. But the point is, if you go after, you better win. And because then, you know, all of a sudden you're not getting good plea deals. And, you know, I'm not saying it specifically. So I think defense attorneys are in a difficult spot. Judges, I give no breaks to. They have no excuses for not referring. If someone prosecuting again, I'm not talking about a minor or something, but if it's a serious grade violation or some other misconduct, the judge should refer the person because they have nothing to lose. But many of them don't. Some of them, you know, and I think that some of them are former prosecutors. Some of them are in courtrooms where they work with the same prosecutors every day, and there's kind of a relationship there, and so they don't want to ruin their careers while someone's going to prison because of what this prosecutor did, but they're protecting the prosecutor. So I think there are a lot of complicated reasons why it doesn't happen, but it does not happen very often.
Your research in Milwaukee, for example, in that program, have you seen some concrete tools that were being used to create the change? Like I'm thinking of instead of single prosecutors making charging decisions, maybe charging teams, these sort of kind of tools that you maybe witnessed being used?
Well, I do know what John Chisholm did there, right? It was based on the research that was done by the Vera Institute, where once the finding was made of the disparities, then he came up with, and working with others in that community, came up with a specific type of intervention program which he implemented in his office. And that's not the only way it can be done, but that's the one example I know that seems to be working.
There on the end, yeah.
Yeah, I think it's being a little bit unfair to prosecutors.
I've been told that before.
Prosecutors, there are creatures of their office, and their office has guidelines, and they don't have individual discretion on what their office guidelines do. If they exercise individual discretion, they are sued in the defense community because they are no longer prosecutors. The changes have to come from the top down.
Yes.
It cannot come, it's impossible to come from the bottom up.
I totally agree with you. Okay, so I'm going to try to repeat what you said. Correct me if I'm wrong. You said I'm being unfair to prosecutors. I think everybody heard that part. You just said that, in individual offices there are guidelines, and that they have to follow these guidelines, and that change comes from the top up, and that individual prosecutors, they have to do what the senior prosecutor says. Okay, I agree with most of what you said. I absolutely agree with you that change comes from the top. It's the chief prosecutor. And that's my whole point. It's the chief prosecutor who sets the policies. It's the chief prosecutor who's the person who's being elected or not elected. And that is the person who sets the tone. Different chief prosecutors have different philosophies. Some of them set a policy, like Larry Krasner in Philadelphia. I urge you to Google Larry Krasner, Krasner. He's all over social media, the stuff he's doing is so revolutionary. But his philosophy is that he came and he said, this is the policy. Everybody, he sent a memo out, this is how you're going to charge, this is what you're going to do, you're not going to ask for more than this amount of time. But not all chief prosecutors are like that. Some of them say, you know what, I'm going to give my line assistants more discretion in individual cases and allow them to do what they want to do. So it depends on the office. And when you say guidelines, that's the part I really disagree with you. Most prosecution offices don't have guidelines, certainly not written guidelines that they're required to consider and follow. They don't have them in their office. That's the problem. That's why I call my first book Arbitrary Justice, because in most offices there are certainly not strict guidelines, most times not loose ones. They leave a lot of discretion to the individual line assistant. And if they don't, the chief prosecutor sets the tone. And that's the person I'm talking about holding accountable, is that chief prosecutor. I do think chief prosecutors should set policies, and they should make sure that their line assistants are implementing those policies. It does not work like that in every office. It depends on the office.
Jeff Sessions said very differently.
Yes, so Jeff Sessions is the Attorney General of the United States, and I will just say, I'm sorry about that. I'm from Alabama, so I take this very personally. I know what that means. But he's the Attorney General for the United States, right? And so, again, the Attorney General for the United States can send out to all the 94 U.S. attorneys in the 94 districts and say, this is how we're going to charge. Eric Holder did that. He sent out a memo saying, we're not going to charge at the highest level anymore because I'm trying to reduce racial disparities across race. Jeff Sessions came in after, and then Loretta Lynch followed Eric Holder. Jeff Sessions came in and issued another memo saying, take all that back, charge at the highest level. Again, he has that top down. And again, but as far as the state and local prosecutors, the chief ones, it depends on the office as to how they implement policy. It varies.
Barbara?
Well, actually, I was going to ask about Jeff Sessions. I'm wondering, until the current administration, I was under the impression that there actually was a growing awareness of the problems, and you've got bipartisan efforts to reduce incarceration and the recognition of racial disparities.
Yep.
But then we get who we have right now, and do you see this as just a fluke that we're going to get past, or is it
I can only hope
I mean, it's
So yeah, it's politics, right? I mean, you had two attorneys general in a row, Eric Holder, then Loretta Lynch. When Eric Holder came in, and I know Eric Holder because Eric Holder was the U.S. Attorney for the District of Columbia when I was the Director of the Public Defender Service in D.C., so I was his sort of counterpart. And, you know, we had our issues, but once he was Assistant Attorney General with Janet Reno and then became Attorney General. And when he came in, he said, it's a new day. I remember his very first speech that he gave, and all these defenders in the audience, and he came and he said, it's a new day, things are going to change. He gave this big speech about racial disparities, and he did make changes. He did, and that's being undone now. And hopefully it will go back if there's another and different Attorney General. But as I said before, only 10%, I know I don't want to say only because I don't want to minimize the harm that Jeff Sessions is causing because there's a lot of harm. And of course the Attorney General doesn't just deal with criminal cases, they deal with a lot of cases and harm is done in a lot of different ways. In the Department of Justice just doesn't handle criminal cases. But in criminal cases, only 10% of all criminal cases are on the federal level, 90% on the state and local level.
Okay. Why is it that so many of these prosecutor races are going uncontested?
I think they've gone uncontested in the past. Thank you for that question. A number of reasons. In the past, and still in the now, although I think it's changing, people just simply don't pay attention to those races. But I think even when they do, it's politics. Running for office, unfortunately, in the United States of America, you have to have money. You know, you have to have money to run for office. That's a whole other lecture, right? And it's sad that our democracy so much depends on that. Money is in our politics. And if you don't have the money to run for office, it makes all the difference in the world. I have seen cases where, for example, Bob McCullough was the prosecutor in Ferguson, in St. Louis County, where Michael Brown was killed, one of the cases that got the most attention some years ago. And he actually had a challenger, but she worked hard, but she failed. I mean, she didn't have the name recognition, she didn't have the money, and she lost. It's really hard to win those races without money. And that's terrible, but it's just a fact.
Second row there.
That kind of segues nicely to my question, which is, I think I hear in your hypotheticals a financial sort of undertone to that. And I don't know what kind of, like, I guess we could say race blind or race neutral or something, studies is a, could you just talk to the poverty versus
Yes.
racial?
Great question. Because it's class and race. It's not just race. There are many poor whites who are treated poorly in our criminal justice system, without a doubt. But race always seems to trump class somehow. I mean, I could give you some examples, of how race doesn't protect. I mean, what Skip Gates, who is a professor at Harvard Law School years ago, you may remember the beer summit with Barack Obama when this prestigious professor at Harvard was trying to get into his house, couldn't find his keys, and the cops came and arrested him on his front porch, right? Skip Gates actually has a show on television where he traces people's ancestry. I can't think of the name of the show. I know some of you may have seen it, right? He got arrested on his own porch, because they saw a black man and decided, and I can give you example after example. So I feel like but it's both race and class is the point. And they intersect. I mean, the poor are disproportionately people of color, and people of color are disproportionately poor. So I think it's hard to separate the two, but you're right. Oftentimes it's class, and again, poor whites, whether they're victims of crime or suspects, also are not treated as well in the criminal justice system. And thank you for making that point.
This question follows from the last two, I think. It's great to hear the stories of the good prosecutors, but I wonder what you think of the argument in the book, The Rich Get Richer and the Poor Get Prison, that the system indeed is not broken, that it is in fact functioning exactly as it is intended to. I just like to what you would have to respond to that.
I think that's probably right. And so if that's what you mean by broken, so I guess I'm using the word broken in a different way, We've heard, I don't know how many of you have seen the film 13th by Ava DuVernay. If you have not, you should. It's a frightening film that shows how intentional actually some of this stuff is, right? How it's sort of designed. Recordings that from back in the administration, the administrators, officials back in the Nixon administration, that sort of intentionally implemented policies that were designed to lock up African Americans and other people of color. And that certainly has happened. When I give my examples, though, I come from a space of, I think that most people who decide to become prosecutors do it for reasons of goodwill. I don't think most people go become prosecutors because they want to lock up black people. I don't think prosecutors sit and say, and my hypotheticals are very artificial. I don't think people say, here's my black defendant, here's my white defendant, I'm going to get this black one. It doesn't work like that. And I don't think people have that in their minds. I think it's unconscious sometimes, right? So I use those examples because I think that's mostly what's going on here. Although I think you're right, oftentimes it is, a lot more egregious and intentional, but I don't think that's what's going on mostly. I think it's more complicated than that, which makes it harder to fix, right? If it's intentional discrimination, we have people say, I'm charging you because you're black. Okay, we can get that person. Through litigation, actually. But you almost need that, right? Because the case law is so tilted that way.
Please join me in thanking Professor Davis.